So, just in case you weren't aware,
Nice,
um,
Jack.
our guest this morning, as you all know, is Andrew Grima from Coleman and Greig Lawyers. He's an absolute gun when it comes to commercial leasing issues. And so he's here to help you guys navigate, or your clients navigate, I guess, the most synergistic outcome for all parties. So I'm going to hand it over to Andrew right now. Thanks,
Thank you,
Andrew.
Stacey. Yeah, thank you. Some of you know me already, but those who don't, I've been practicing for about 25 years now. And I do other aspects of property law, and I've done other aspects of the law, but my one constant through my entire career has been commercial and retail leasing. And that's everything from big, working on big industrial sites all the way down to a small corner shop, landlord and tenant focus. I've acted for big retail groups, and I currently act for a couple of big retail groups nationally, as well as all sorts of other things, subsidiaries, multinationals, national companies. So there hasn't been too much I haven't seen in leasing. But the last 18 months is probably been the most interesting and most sad in some respects that I've ever seen when it comes to the world of tenancy law and commercial and retail tenancy law. So I've cut my teeth in my career on being a deal maker, a commercial guy who negotiates transactions. And I've been involved, you always are involved in disputes, but suddenly I've gone from being sort of part of my practice being just a small part of my practice being disputes to probably half my practice now. And but it's been quite an interesting way in which I go about doing it, because historically, if you get a litigator involved, it's all about the court case. It's all about trying to, drag the matter on for forever and a day, and it's all about who's going to win. But in these sort of matters, being commercially minded is probably the most important part of it all. And adopting a commercial bent and being a transactional lawyer, that's the only way. I've been involved in quite a few mediations in the last 12 months, and they're quite interesting in themselves. So what I aim to do today is walk you through the current legislative framework, compare it to last year, clarify to you where we're actually at right at this minute, and then give you some examples on how to navigate it through. And that means whether it's just, you don't have to end up going, whether you go to mediation or not, and talk to you about the mediation process. I'm hoping to be able to tool you guys up, because presumably, and I saw this last year, people don't, not that I'm trying to wash my hands of work because I want the work, but people who are in this situation can't afford to pay legal advice if they're really in a bad situation. So what I've been trying to do over the last 3 or 4 weeks is get out to as many different people, like property managers and different people, to say, okay, I will tool you up so that you can try and resolve it without needing to come to me. And generally I found that people came to me when it was at a last resort and they needed, and generally when they come to me is when the people are actually trying it on. So you'd have, and the classic stereotype example would be a landlord who owns a property, it's their super fund, and they've got some absolutely shocking tenant who actually is making a buck still, and they know because they're watching them go in and out of the premises and customers going out of the premises. They might be struggling a bit, but they can still pay their rent, and they're just refusing to pay their rent, and it's a try-on. Or where the parties just hate each other's guts because of something that happened 2 or 3 years ago, and it's almost akin to a family law dispute. And some of you may have been involved in or been connected with family law, you'll know what I'm talking about. And where something's festering, and so COVID's been an opportunity for someone to get paid back. And then I've been involved where people actually do resolve them quickly, and we organise a short, sharp deed of settlement. So that's how my background, but I've seen a lot of stuff over the last, as I said, the last year and a bit. So let's start with where we're at in terms of the legislative framework. And it was interesting. I did an article about probably 2 or 3 weeks ago now, which went on social media, and I called it COVID-19 Regulations 2021 for Retail and Commercial Leasing, the Great Stalemate. And so what happened was, to their credit, towards the end of July, last third week of July, the state government introduced a piece of legislation. They basically introduced the fourth instalment of the COVID regulations. So last year, if you recall, there were actually 3 different instalments of the COVID regulations. There was the initial one that went from April, just after Anzac Day, to September. Then an amendment as the JobKeeper rules changed that went from October to December. Then the final set that went from December to March. Then this fourth lot, quite interestingly, where we were at in the 3rd week of July, we're covering the period from, mid-July to the 20th of August, which would have been, a couple of days' time, or today, or tomorrow. As of last Friday, Damien Tudhope, the Small Business Commissioner, issued a press release on Friday. It was late Friday to say, we're now going to change these regulations further. These regulations have not yet come out. I checked the government website again this morning, and they still haven't come out. They might come out this afternoon. So when I'm talking about what the current status is, I'll be talking to the press release. It is, I'm surmising, but it will probably be right. But if you just keep that in mind as well, but the general principles will be the same. So just where we're at. So the critical piece, and I'm going to be stepping you through some key terms that I know now in the current regulations, and then I'm then also going to then expand on that based on this press release. So as of currently, the law goes law in the land at the moment, is that for a prescribed period, and that prescribed period was the 13th of July 2021 to the 20th of August 2021. As per the press release, that prescribed period is now going to extend to the until the 13th of January 2021. The landlord cannot do certain things. I'm just getting my notes back in front of me. Sorry, guys. Cannot take certain action. Cannot take certain action without first going to compulsory mediation. Now, and so they talk about prescribed action. So what does that mean? It means a landlord can't sue a tenant, a landlord can't lock out a tenant, a landlord can't call on a bank guarantee, a landlord can't charge interest, they can't do any of those normal things that they were entitled to do as a landlord under the lease if a tenant is in default, unless they first go to mediation and that mediation fails. The difference between this year's regulation and last year's regulation, the critical aspect is what is an impacted lessee, and that is the fundamental first port of call. So if you're advising tenants or you're advising landlords, that is the first critical piece of information that you're going to need to get to the bottom of. So what is an impacted lessee? An impacted lessee is, first of all, a tenant that has turnover of less than 50 mil in the 2020 to 2021 financial year. And that is exactly, that's the same definition as the last year's regulation, so tick. The second part of that definition of what is an impacted lessee is they've got to qualify, the tenant has to qualify for one of those 3 state government grants: micro business COVID-19 grant, or support grant, COVID-19 New South Wales business grant, or the JobSaver grant. Now, I'm going to step you through those. Some of you will know what they are, but I'll step you through them again in a minute, because it's important that you understand what they are. So if you're a landlord, you can be saying, and your clients are landlords, or your contacts are landlords, you can be saying, well, show me this first. Or if you're acting for someone and they need that advice, you can step them through what they actually need to do. Now, just interesting in the way that the regulations are drafted, it talks about the tenant is being required to provide a statement to the effect that they are an impacted lessee and evidence of the same. So it's only just, I think now, and I'm not sure if anyone has yet seen the evidence of what you get if you qualify for one of these schemes, because the government's been so slow in getting the machine working. But as I understand it, you lodge your application, and again, I'll go through that in more detail in a a minute, but you lodge your application, you get a confirmation to say the government's received your application, and then at some point cash just appears in your bank account. So the first issue is going to be where parties, particularly where people are a bit edgy about it, and if you're a landlord trying to really put the pressure on the tenant, the landlord's going to be really scratching around to have reasons to say, show me you haven't proven to me that you've qualified. And if you're a tenant, you're going to be really edgy about this because you're wanting to show the landlord something. To my mind, what I landed on in many of the mediations I did last year was the simplest way to prove that a person is getting one of these grants is just to get a blacked out bank statement which shows the money in the account, because in the end, that's the absolute proof that you've got that you've received the money. The other interesting thing is that the tenant has to, it talks about as soon as possible after the breach occurs, and they must sort of provide this proof, and it must be provided in a reasonable time after it's requested by the landlord. Okay, so then there we go is a problem again, because in the 25 years I've been doing this, I'm yet to really come up with a definition of what reasonable time means. In the old-fashioned word, it means the person on the Clapham omnibus or the person on the Bondi Beach bus as to what is reasonable. So we don't actually know what reasonable time means. So at the moment, is reasonable time 6 weeks or 8 weeks, or is reasonable time 2 weeks? And I think that's going to move along depending on how quickly the state government starts getting their machine working better. So that's going to be a point of debate that we're all going to have to muddle our way through. And my advice is, if you're acting for a tenant and a landlord is saying to you, well, show it to me, you need to be reasonable about this, you can say, well, your biggest is feed them the information, show them the application you've lodged, show them, and if you don't want personal information in there, black out what you want to black out, show them that they got the number. So you got proof that you've actually been moving and you've been taking reasonable steps. If you're a landlord, I think we're acting for a landlord, I think you're going to say, hose them down a little bit and say, calm down. You've got to be reasonable about this, because you can't take any action against the tenant anyway at the moment anyway. You're not going to be able to lock them out. So I think you've just got to be, you got a bit of a common sense approach there has to happen. And if you ultimately end up in a mediation, I think one of you guys said you're a mediator now. If you're sitting in a mediation, a mediator is going to pull you aside if you're in a dispute and say, well, come on, let's be reasonable about this. The other issue is, and I'm getting questions about this, and I have had questions about this, is what about if the tenant doesn't quite fit in the box of the breach? So what if, for example, it's for something that happened between the regulations? So some breach that happened between March this year, between the end of March and July, or what happens if, for example, it's some other breach, like the tenant's damaged the property, or the tenant is holding over. The legislation there's a notation in there, and the regulation is crystal clear on this, or the current version is, and who knows whether it will now change. But on current drafting, and it was the same as last year, there was notation that said it's got to be, a landlord isn't prevented from taking action on grounds not related to the economic impacts of the COVID-19 pandemic. So, for example, and there's a notation in the regs that say, I give an example, if there was termination in the event of breach of lease, is an example, as a result of damage to the premises, or if a tenant has failed to vacate after they've been given a notice to vacate because the lease has come to an end and they're on a holding over basis. So that doesn't prevent a landlord from doing that. And I've got matters where that is happening, and particularly, look, where the tenant is a good tenant, you might not do that, but where the tenant is troublesome, that may be an issue. Or if you're a tenant and you're in that situation, you are exposed. So you must keep that in mind. What happens for these periods between March and now? So it would be a brave landlord to really act aggressively in this environment, because there are still court cases. There's only about 5 really clear court cases on COVID that came out, and the famous one is the Sneaker Boy case. And I use that as the guiding principle. In the Sneaker Boy case, the court, and this was relating to breaches that happened prior to the regulations coming in last year, the NSW Supreme Court were quite clear on this, that was saying to the effect of, that the tenant is entitled to relief against forfeiture, provided that they can show that they are in a position to be able to rectify their default because they had a bank guarantee in place, and at some point they can replenish that bank guarantee. So what does that mean in layman's terms? It means that the court is going to probably, where possible, err on the side of the tenant, and it's going to have to be pretty clear evidence of the tenant having a bad track record and not being able to be in a position down the track to trade their way back in the black. And so at the risk that you run as a landlord when you lock a tenant out and they've suffered loss, for example, if they're a food business and frozen goods perish or they lose trade, you're in a firing line to be able to say, well, you've caused them further loss. So even though they're, depending on where they are, they might not be trading that well, but at least they're trading somewhere. You don't want to put yourself in that situation. And the other thing is, of course, you want to weigh up locking a tenant out or not at the moment, because you're going to be able to get someone else in. Maybe in an industrial or commercial, like a factory, you might be okay because, there are plenty of people putting their hand up to want to take industrial sites because of this whole click and collect and, e-business. But if it's a retail shop or if it's a commercial office space in particular, are you really going to be able to get in anyone else in at the moment? So you're better off muddling along if the tenant's paying you minimal money than in a drama of having to deal with the mess of locking someone out, which might include even having to dispose of their fit out or their goods that have been left behind. And if someone's got rights to those goods, having to be able to dispose of them without being sued for if someone's got some sort of charge over those goods. So there's all those various nuances that you might want to think about, or having to deal with a receiver. If you ever go down that path, it is not a easy experience. So I think it is critical that you think about those things before you press go, even if you're legally entitled to. The other thing is, so that was. And the other thing was too, it doesn't apply, the current regulations don't apply to leases entered into after 26th of June. So I've been saying to people, all those leases, strictly speaking, that we all rushed through in the dying days of the end of the financial year before all this nightmare entered our lives, a lot of those leases will not get the benefit of this regulation, strictly speaking. So that's part of the framework we've got. And the other part of the framework is I'm now going to talk to what Damien Shoothope released on Friday. So what it looks like is going to happen, and again, the proof is always in the pudding of what they draft. And these days when things are drafted fairly hurriedly, there's always nuances, there's always errors that we have to keep our eye out for. But it looks like what they're going to do is they're going to reintroduce what they did last year, which was the New South Wales regulation piggybacked off the National Code of Conduct. The National Code of Conduct, remember, was what the federal government introduced in early April. They had a set of guiding principles to work out these rental reliefs, but said, over to you, states, now to pass your laws. And the centrepiece of that regulation was a tenant is entitled to rental relief based on the fall in their turnover or revenue. And then it became a question of accountants at 50 paces to try and prove what the fall in that revenue is. And all of you probably in this room have been there and done that. And part of that was working out the true fall in the revenue. The guiding and where it landed of consensus was the most reasonable approach was grab BAS statements to compare year on year. Just work out the true extent of the fall in turnover, bearing in mind there's all sorts of little funny things that you need that will cause everyone a headache. First of all, where often you'll have sometimes you'll have a tenant entity as one party, but the business is another entity. What do you do about that? Or where you've got a company that has multiple sites and it's just that one particular site that's not performing at its best. So it's about trying to get around that issue. And then the other issue is, I'll saw a comment from Anil. I'll have a look at that in a minute. The other issue is Okay, so and what I ended up doing in a lot of the disputes I got, particularly in mediation, where I knew it was a bit of a try on from a tenant in particular, and I was acting for a landlord, or I was a tenant who I knew was trying it on, or it was hard for us to really prove our revenue for without giving them the information that we were finding it hard to get hold of for whatever reason, is we said, okay, if you qualify for JobKeeper, it was assumed you had a fall in revenue of 30%, unless you're a non-for-profit and the fall test was different. But if you assume you have a fall in revenue of 30% because you qualify for JobKeeper, that's your fall in your revenue, and that's your starting point of the discussion. And let's all just go home after that. Which I'll go through in a minute. It's the same test in these current New South Wales schemes. It assumes a 30% fall in revenue. So I think that's what you do. Then the second part of the discussion and the debate will be around how do you actually package up that relief? So say if your relief is, say, I'm going to use the number 30%, might be more, it might be less. It said, how do you split that relief between a waiver and a deferral? A waiver means you never have to pay it back again. A deferral means that you have to pay it back at some time. Based on what the press release issued, it'll probably be the same thing where they'll say use the National Code of Conduct and say at least the ratio of waiver versus deferral has to be at least 50%. So in other words, a tenant would get at least a 50% waiver of that relief. So if you said the relief was 30%, you'd be entitled to a 15% waiver and a 15% deferral, unless you can argue for higher. And then it becomes a question of, okay, so how do you package up that deferral? Under the rules last year, you had a minimum of 2 years to pay back that deferral. The greater of 2 years or the term remaining under the lease, unless you negotiated something different. In most of the deals I did, where even the ones that didn't get to mediation, it was often negotiated a shorter period of time to pay off the deferral, and that was a trade-off for getting a decent waiver. But again, it's going to be a case by case how much you can prove. Now, if you come to a deal, how do you document it? I have seen everything from exchange of emails to letters to deeds of variation to deeds of settlement to variations of leases. I'll go either end and say either end are not suitable. So I think you're crazy if you just do sorry, I've got someone trying to join. I think you're crazy if you just do an exchange of email, because it's going to get lost at some point, and I query the bindingness, I query what the terms will be, particularly the ability to go back to that and say enforce it, and I query going to the expense and the effort of doing a variation of lease. My view would be the simplest way, and there are plenty of them floating around, a lawyer would be able to do it for a few $100s, maximum 500, is a deed of settlement, which effectively tells the story. This is what the rental relief is. This is where it's going to be paid back. If it's not complied with, it's deemed to be a breach of lease, and the landlord can call on the bank guarantee. Boom. And that's probably where you'd land if it was me. So, and then with some other little, and I'm going to go to the government schemes in a minute. There's some other little niceties that were announced in that press release last week. It included, and again, I don't really know what that means because I haven't seen the devil in the detail yet, was where he talked about landlords who rely primarily on rental income, that they would be able to access a monthly $3,000 grant to help ease the burden and ensure that as long as they pass that rental relief on to tenants. We don't know really what that means and who's going to qualify for that, but that is something to think about. So if you're a tenant, you could ask the landlord for that. And if you're a landlord, you'd be trying to seek that. The other thing is, which I'll go into in a minute as well, is land tax. So landlords will be entitled to a land tax reduction, provided they pass that on to the tenant, and that has a whole lot of problems with it in trying to administer that. And what I'm hearing out there in the marketplace, particularly from landlords, is it's not worth the drama in actually doing it, because the amount of cost you've got to go to try and administer it. But I'll talk to that in a minute. Before I jump into the New South Wales schemes, does anyone have any questions? I think a message came up on the screen. Did anyone want to talk to what they have asked so far?
No, my message, Andrew, was really just, I know as part of the application process for grants, you need a letter from your accountant saying this is what your current revenue is, this is what it was the previous period, whatever it's 2 years ago or last year. So that would possibly be a way to establish the drop in revenue.
Yes, I agree. And that would be something you would probably, if you're a really rigid tenant, and as long as you're comfortable with it and your accountant is comfortable releasing it, you'd produce that as quickly as possible as your starting measure while you're waiting for the application to
because that could show a 70% drop, for example, because I know the New South Wales COVID grant was 30%, 50%, or 70% drop.
Yes.
You got different. So it's in, so that sort of information may be there.
And I think that's important because don't just lock into a number. And I want to say that as well, how there are various ways in which it's been, I've seen it structured. So I've seen just, okay, X% per month, and it's agreed locked in monthly waiver over a finite period. I've seen it worked out on an average fall based on the real data, so 50 month, 71 month, 31 month, and you average it out. I've seen the real hardcore landlords say, okay, we're going to assume this is your fall, but then you've got to give us numbers every month, and we're going to do an adjustment in your rental statements.
Yeah.
And none of them are incorrect, by the way. But I'm also saying to everybody, particularly landlords, because when I'm talking about landlords, there's a difference between those big groups of landlords, big companies, and by the way, they are suffering too, by the way. Don't get me wrong, but particularly your smaller private landlords who are running their properties are their super funds or their retirement money, and I've got clients like that, it's actually their retirement money. I'm saying to them, don't jump into something too quickly. It's all going to be on hold anyway at the moment because the tenant's not paying you rent or is going to be withholding rent or whatever. You can't do anything about it. Really come to a proper, sensible, reasoned response, because I saw a lot of people last year, particularly around March, jump in really quickly and lock themselves into some deals in the end that were if it could have, either way, either party may have been unfavourable in hindsight.
Yeah. You're
once
right.
we had a body of data.
You're right. Some businesses had an immediate drop, but then they recovered quickly, and then or those businesses actually had worse drop, and then they had to go back to the landlord put their hand up again, which is even harder then, because landlords say, "I've already given you relief. What are you talking about?" Yeah.
So it's hard for both of them.
Andrew,
so I think,
sorry,
yes,
just going to make a point. So I've seen clients of mine who've had some of the grant through from the government, and it's in an email. Yes. So I think it used to be just paid into the account. Now you actually get an email, and I've had that used as evidence to give to landlords. So
fantastic.
Yeah.
Okay. That's good. So this is what's good about everyone catching up together. They sort of feed off each other, find out what everyone's hearing and seeing. Just in terms of those grants, so again, you guys, obviously, I'm probably speaking to the converter, but for those who are not sure, so you got 3 of them. One's the business grant, and that's at 7.5 to 15 grand, depending on the client turnover. That was based on a decline in revenue of 30%, annual turnover above 75K, payroll up to 10 mil. So it's quite a few businesses that are going to be able to qualify for that. And where I'm coming from is more to talk about the ability to then put your hand up to claim rental relief. So that's one way to qualify. The other way is the job saver, which I think is the biggest one. I think a lot of people are putting their hand up for now, from what I understand, because the eligibility is, again, a revenue decline of 30% or more and a turnover between 75 grand and 250 million. So it's quite a big threshold. Now, obviously, bearing in mind your turnover has to be 50 mil or under to do these rental relief schemes. So obviously the 250 mil people aren't going to be able to get the benefit of rental relief schemes, but it just shows you the sheer size of the number of businesses who are going to be able to get over the threshold of government assistance to be able to be in the game for rental review and rental reduction potentially. And how much do you get? It's actually quite generous. It's 40% of the weekly New South Wales payroll, with payments between 1,500 and 100 grand a week. And if it's a non-employing business, it's about $1,000 per week. And I'm sure the accountants or the guys who have been putting those applications together would know that the goalposts had moved quite a bit. So it went from, I think, relying on year-on-year numbers to comparing, say, your June numbers with your July numbers. So it's become easier to get that JobSaver grant, as I understand it. And I don't know if anyone has a comment on that. But I think it's been a lot. The ability to claim it, it's moved around a bit. And then there's that micro business grant, which is with the business that's between 30 and 75k, earning 1,500. You get 1,500 a fortnight. It's where your turnover, as I said, between 30 and 75k, revenue decline of 30% or more. And the business, that's where the business provides income that is a primary income source for the person associated with the business. They're your sole traders. They're your small business people. So why it's important to talk you through this is, A, if you're acting or representing a tenant, then you know, okay, well, these are the three that you've got to really focus on. And obviously some of you already know that. But if you're representing a landlord and you've got to know these things. So when a tenant comes and puts their hand up, you can know clearly what they should be showing that they've qualified for. And even, in any event, even if you didn't have a rental relief scheme in place, you'd be saying that as a bit of a due process thing. Well, what else have you done to get assistance? And I suppose you've got to be careful and not be disingenuous about it, because some of these businesses, and I've seen them, they're going through hell. Like, I could only, but by the good grace, I'm in a job I'm in where I'm so far going okay. But imagine if you're running a hairdresser or a gym or a beautician or a cafe or any of those businesses, how hard that must be for them right now. I don't know. Just because you're never going to get that money back. And so it'd be tricky. And similarly, if you're a landlord and you're not getting that money in, you've got a loan to pay, how long are the banks going to back you for? And then at some point, you've got to pay back the interest. So, so I suppose I'm not trying to be moralistic, but I think my shout out to everyone is, I think we're all got to be a little bit sensible about this and fair about this. Then the only thing I want to talk about is land tax. So it's doing everyone's head in, because the way it works is, first point is to qualify for the land tax reduction. It's on the landlord to show that their tenant qualifies for any of those three programs I've just talked about. First point. Second point, then you actually have to show you've given the tenant rental relief. And then the third point is, what everyone's trying to get their head around is, so can the landlord, there's no benefit to the landlord in doing this. And maybe I'm wrong here, and I'm happy to be challenged, because we're all trying to muddle through this. But effectively, the landlord gets the land tax reduction if they give the tenant the rental relief, and they get the land tax reduction to the extent of the rental relief. So does that mean then, if the so what if the tenant is paying land tax separately as outgoings? What if the tenant is paying rent, or alternatively, the tenant is paying rent on a gross basis, which is where they're paying land tax separate? Does this mean now what's going to happen is, particularly now that we've got this rental relief, it's now going to be legislated with it, it's all about rental relief as well. Does that mean the landlord's going to be faced with, sorry, I've just had a call come through. Sorry, just call came through on my iPad, which for some reason my home is all synced to the one thing, so I apologise. So does that mean that does that mean that you've got to give the tenant rental relief, and then separate to that, if they're paying land tax or contributing outgoings, you'll give them a land tax reduction? If you're a landlord, you're going to try to minimise that. If you're a tenant, you're going to try and seek it. If you're a landlord, if it's a nil-all draw, you'd probably try and help your tenant out. It's a way of giving them assistance. And then the landlords are saying, well, it's not worth our while trying to claim the land tax relief. And if we don't have to give it, why are we going to bother trying to pay our accountant or our property manager to administer and do this. The other issue we have is, as an aside, is if you are a property manager looking after all this, you're not actually getting paid for it. So you usually get paid a management fee, and it's going to be, there's a whole lot of hard work for a whole lot of people where they're not actually making any money out of this as well. So that's why you probably want to, everyone wants to use a bit of common sense about this, because the more time it's spent in trying to resolve these issues, it's a lot of people are losing out here. Then what I want to talk to you about is the mediation process. So assuming you've had your discussions and assuming that you can't get an outcome, you have to go to compulsory. The last year's regime and this regime is the same. You need to go to mediation first before you can then take the next step, which is then, if you're a landlord, suing a tenant or locking them out. If you're a tenant, trying to get whatever you need. And if you're a tenant, you want to be seen as having clean hands as well. So you want to try and then, as a last-ditch attempt, go to mediation. So the mediation process, for those that you have never done it, is it's a very informal process. To instigate a mediation, you go to the Office of Small Business Commissioner website. It's a 4-page application that is filed. The applicant's party's details are listed, as is the other party or the respondent. And if you're represented by a lawyer, you put your information there. Relevant contact people, what you're trying to achieve out of the outcome, and attach relevant documentation. And that's usually a copy of the lease. You may include other things like submissions of arguments, but generally you wouldn't. And you put what you're trying to achieve, which is effectively to get, if it's a landlord, to recover rent of X dollars, and if it's a tenant, it's to try and obtain relief of Y, also so you file it, and literally within seconds you get a little acknowledgement to say thanks for your application. A case officer will be appointed. You get a number. About anywhere between 2 weeks to 2 weeks to 3 weeks, a case officer will be in contact by email saying, I've got your case. I'm trying to reach out to the other party to lock in a date. A case officer is a very important person, because if you don't hear anything, then you might follow them up every couple of weeks. They are very helpful. They may even have a bit of an offline, off-record conversation as to where the other party is at, if they've spoken to the other party. And ultimately, they'll hopefully track down the other side and lock in a date with you. At that point, a mediator is appointed. The mediator is usually employed by the Office of Small Business Commissioner, or is an independent party who is a mediator, who's actually a trained mediator, usually either a consultant in the industry or a former lawyer or a former judge. And everyone I've had so far has been fantastic. And so they're appointed. They will usually reach out to you in the week or days leading up to the mediation. You'll need to sign a mediation agreement, whoever is involved in the mediation, whether it be the actual parties or their representatives. You'll need to pay a mediation fee, and you'll need to have clear authority to make decisions on the day. The mediator may then at that point ask for any additional information, and this is critical. So you've got to be careful, because you might have put an application in, say, August for mediation. The mediation's in October or November, because that's realistically the amount of time frame you're going to be looking at. And the rental debt is accumulated. So if you're representing a landlord, you want to be clear to make sure that you update the amount and say that before the mediation, to give an updated statement, so that the mediator doesn't say, hang on, now you're first of all arguing over 50 grand, now you're arguing over 90 grand. How does that work? So you want to be as cooperative and be the one on the front foot as much as possible during these mediations, and be cooperative, because the whole purpose of the mediation is to try and resolve the dispute. It's to try and get into that room and have an outcome. The mediation is confidential. The mediation, what stays in the room stays in the room. It can't be used in litigation later on. And the reason for that is it encourages people to be frank. And often what I find is in these mediations, a whole lot of other stuff comes out that had been festering. And you might go from talking about rental relief to, okay, these repairs need to be done, to, okay, we want to surrender now and let's negotiate that surrender. The mediations are done like we're doing now by Zoom. Some mediators use Zoom, some mediators just go by phone. And the mediator is not a judge. The mediator is there to steer us and guide us. During the mediation, the applicant will state their case, the other party will state their case. You'll pretty early on get a gauge of where everybody's at. There'll be a point where everyone will break into their own little meeting rooms, and they'll be done virtually. And there will be a discussion around, between, so if I'm the client, we work out, okay, where we're at now, depending on what the response from the other side was, what they might be proposing, or if they've rejected a proposal from us, where do we go to from here? The mediator will then step in and be a bit of a get real type barometer to say, well, look, I can't really judge you or steer you, but have you thought about this way, this or that? And the mediator will then go and do the same thing to the other party. And where it always goes back to, and the mediators will often say this to the parties or suggest this to the parties because they can't judge or tell you what to do, but I will certainly tell my clients, okay, we're arguing over this particular issue now. If we don't get this resolved today, it will end up in court. And if it goes to court, it will drag on for a long period of time, usually a year or 6 months at the very least. Many, many thousands and thousands of dollars later in legal costs to basically often reach a settlement on the steps of the courthouse on the day of the hearing after paying barristers and experts and all the rest of it with money you don't have, to only get the same outcome that you got right now. So it's very much about trying to be pragmatic about it during that mediation and turning the other cheek and biting your tongue and not talking about, well, it's the principle of this and all the rest of it. It's about reaching common ground. The other thing I find often in these mediations where it's an argument over numbers, particularly if you're the aggrieved party and you want it to be accurate, it becomes a question of spreadsheets at 60 paces. And a lot of the argument will be around the finer detail of what the numbers are. And then there'll be an argument about packaging up how whatever debt is there to be repaid. And then what happens is when the mediation finishes, a heads of agreement is entered into on the spot. And often if I'm there, I type it. The parties sign it electronically, exchange it electronically. Back in the old days when we used to do these, when I was first in practice, it was all done by handwritten notes. Now it's done electronically. And then with an undertaking to then produce a deed of agreement that the parties will enter into in the coming week that is reflective of those terms that were reached. The deed of agreement is all about saying this is a legal document, it's binding on the parties, can't be used in proceedings apart from enforcing the covenants in that agreement. Mediations themselves, I found, can last anywhere from half a day to all day to be carried over. So I had one mediation that went from 10 in the morning till 7 at night. I had another mediation I've done recently that's been held over for another day because the other party wanted more information and assess what we're proposing. I had another mediation that dragged on for weeks. We did the mediation, and then I was going backwards and forwards with the mediator, as was the other party, to come up with an outcome. The mediators really don't like it, and the other parties won't like it if you rock up the mediation but don't have true authority to come up with an outcome, or, we've got to get the CFO's instructions or the CEO's instructions. You need that authority on the day. But every mediation I have, as long as we got into the room, the mediations I've participated in, we have resolved them, have had a good outcome for everybody. The mediations that never got off ground, well, they ended in tears. Like I had one, we tried doing a mediation, didn't work, my client ended up getting locked out. I had another mediation I wanted, but the other side doesn't want to do it, and we're still to this day negotiating. We were almost there, but then COVID struck, and now we're back to square one. That's what I had to say. Did anyone have any questions? That was the bulk of what I was going to talk about today.
I've got a question.
Yes.
You mentioned about a $3,000 per month relief to landlords.
Yes.
So your tenant has to qualify first, and then you can claim that on the back of your tenant qualifying for, or how exactly does it work?
They haven't given us any detail. It's a byline in the press release.
Oh, right. Okay.
Yeah, so I'm hoping that's going to be somewhere either in the Office of State Revenue website or in these COVID regulations that come through. They haven't given us the detail yet.
Because one thing about this is, the tenant and the landlord bear the cost of all this, and then the bank, all the banks get a free ride basically. They'll defer it, but they don't take any haircut at all.
No, and that's exactly right. So there's no. And that was what they were trying. I think last year, why it took so long to get. Remember, if you broke out in March, and we're all sitting around for about a month stressing about this, right? Because the federal government was trying to be all things to all people, and they had all those key industry stakeholders had a seat at the table. So there was, property council, retailers association, banks, and they were hoping that everyone would take a bit of a haircut on this. But in the end, the banks didn't take a haircut. They just sort of said, well, look, we'll defer it where we can. But all they did was defer. You still have to pay back the interest ultimately.
Compounded interest, probably.
Yeah, exactly right. So that's why I'm probably suggesting if you're a landlord like you guys are, I know, Dylan, you're better off having a bit of if your tenants are the ones that are not struggling, but they kind of are, and they're trying it onto you, you're better off giving them something to make it go away to get it resolved quickly so you start getting money in than sticking your foot in the ground saying, no. Because a bit of something's better than nothing, and the longer you dig your heels in and end up making an enemy with your tenant, the harder it's going to be. And the other issue you've got is you're stuck with these people. If you sign them up for 3 or 5 years and they're probably only relatively new into the tenancy, they're going to have long memories, and they're going to make your life a misery down the track if you don't accommodate them in some way now. I might be wrong there, but that's my experience. I've seen people have long memories. And it's not a judgment on anybody, but it's the reality of the way it works. And people will say, "Remember that time when my back was against the wall," and their back might not have actually been against the wall, but they'll use it. Don't you worry. So you're better off cutting and running as quickly as you can to get it resolved.
Yeah, I was going to say, Andrew, it gets back to relationships. Like I've got a very good relationship with the landlord, I have from day one. And that's helped in these negotiations. And knowing that I'm going to have to have a relationship with him moving forward as well, you want to keep everything sort of as easy as possible, We've had some very good discussions. It hasn't got out of hand. It's just been very cordial and all that sort of stuff. And that's how I do a lot of my business relationships with, contractors and suppliers and, staff and guests and all that sort of stuff. It's about the relationship as well. That really helps the situation.
Very much so. And I find where the relationship is toxic, that's where you end up in a mediation or a lockout.
Andrew, I was going to say, sorry to interrupt you. So I found that there's also in the COVID regulations, it talks about extending the lease for the equivalent period of a deferment period.
Yes.
If there's a lease expiry, which is we're just discussing with a tenant at the moment. So that's quite an interesting one.
Yeah, that was in the code of conduct last year, right? And so it's not mandatory to do that, but it's something the parties can do. And that's probably probably a good compromise, particularly, give to get type of thing, where if the tenant is really desperate, they might be willing to commit to a longer term to try and catch up. The problem with that is obviously it's a bit of a gamble on both parties' situation, because if this continues intermittently over the next 18 months, hopefully it won't, but if it does, then an extension of 2 years is just going to be delaying the inevitable as well. But if that's a way out for the tenant, then okay, well, I think it's worthwhile. But the sting in the tail will be you still got to pay back your deferral, and the deferral will be repaid. So you'll be paying the extra 2 years. Over that extra 2 years, your rent was going to be blah, but it'll probably be increased to cover off the deferral or the waiver, I will bet. Or there'll be a point where people will catch up again. So remember last year too, a landlord couldn't even increase rent. So that's been the other thing as well. that the regulations are silent on that so far, but I'm sure when they amend the regulations, I'll whack that one in as well. But it is, to answer your question, it is a mechanism people have used. But you just got to watch what that really means in terms of how much extra burden is on the tenant down the track. Yeah.
Okay. Thank you.
By the way, if you're negotiating those, another alternative is to, particularly if they're retailers, it doesn't have to be retailers, but team seems to be an easier one and a more accepted commercially to do, is you look at converting your rent to a turnover rent more. So there are turnover rents in retail leases already, but make it a more definite. So for a blank period of time, say 3 months, 6 months or whatever, you might have a rental mechanism that is capped occupancy cost of the greater of or the lesser of a fixed rent and an X percentage of sales. I've seen that work pretty well as well.
Hi, Andrew. Thanks for the presentation. Just a quick question. Yes, one of the challenges obviously try to weigh, the amount in dispute and whether it would be worthwhile to go to the next step. So my question is either half-day or one-day mediation cost. Do you know roughly how much it is?
Yep. So the mediator's cost is just it's and I won't give you the exact number because I never remember. It's around that $630 mark. Each party has to pay the mediator, and that's paid. So what happens is when you get your application approved, and just before in the days or the weeks leading up to the mediation, you get an email from the Office of Small Business Commissioner that says, "Can you please pay $630?" I think it was $618, but it's gone up. I think to $630. And each party has to pay that. And that represents 4 hours worth of mediation. So I had one where it's been held over for another day. So my client has to pay an extra $630. So each party pays $630. And then it's the legal costs of attending to the mediation itself. So as a rough guide, if I do a mediation, how I do it is I charge a small fee to lodge the application, and that's usually around that sort of $500 mark. And then to attend the mediation, and that includes preparation, all the bits and pieces. It can be anywhere between, depending on the parties and how long it takes, anywhere between the $2,000 to $2,500 mark. And it could be more if it drags on for a few weeks, but it's around that number. If I get involved in the work leading up to it before the mediation, so if I get involved in the dispute, so I try and charge it again because people are struggling a bit. So I'll charge a flat fee to do a letter, which is usually hey, this is what we need from you. If you want us to give us rental relief, this is what's going to be. And then if obviously there's all this whole lot of rigmarole between then and the mediation, then I have to look at a case by case basis, and it goes by the hour. But it just gives you an idea in terms of your client's budgeting for it.
That's great. Thank you.
No worries. See you, Anil. All good. I just got a message from Anil to say he's leaving too. So, did anyone have any other questions?
See you, everyone.
See you, buddy. Good to see you, by the way, Anil.
Yeah, good to see you too, mate.
No worries. Did anyone have any other questions they wanted to raise? Looks like not. Stacey, did you want to add anything, or is there anything else we need to do formally?
Not formally. I'll just stop recording, perhaps. That would be
Yeah. Well, I want to say thank you, everyone, for listening in today, and I hope I was assistance to you. Please reach out if any of you do need any further assistance or just to talk to me about